Hey everybody, Graham here. So I wanted to go through the new filing in Johnny Depp's appeal against Amber Heard because I think it's just a beautifully constructed argument. Nate the lawyer said, I think on a stream, that because his brief is also pretty awesome, and Dr. Hines Emmett and I went through it on a live stream, so you can hop over to his channel and see that if you want to. But he mentioned that when you're writing a brief for a case that there's public interest in, you write a little differently than you might if you were just writing for the court. And I think Ben Chu has done that wonderfully here. There's legalese where there needs to be legalese, but for the most part, it's a very clearly written document. Now, I don't want to go through the whole thing because I try to keep my videos on the short side. But I do just kind of want to look at it and point out just how beautifully it's constructed, and how if you read through it, you can see that they've got a reasonable argument here. I mean, some of the law tubers, at least what I've seen so far, saying, this could actually fly. This has got some merit. Doesn't necessarily mean he's going to win, but this is not just a frivolous counterclaim. So we're going to take a look at it. I'm mainly just going to go through the table of contents because it shows the structure of the argument, which is the sort of the main thing that I'm interested in. Though I may pick out a couple of text samples because I love the way Ben Chu writes. But at first, before we even get into any of the meat of the document, I just want to say how much I like the little font here on the cover page. As I was going, looking for this document, I noticed on the Virginia court website that they've got a template for the cover page, so I assume that's where this font comes from. I think it's lovely. The rest of it is all just, Times New Roman or whatever, and it's, eh. But so, looking at the table of contents here, the statement of the case is just sort of a review. The introduction lays out what they're going to do, which is to say they're appealing this one particular verdict. They're pretty specific, and I actually thought this was kind of funny because they're saying, we're only appealing this one statement. We're not appealing the other two statements that Johnny won on, or any of the three of Johnny's claims that he won on. So we're not appealing that anything Johnny won, we're only appealing the thing he lost, which is something that you would think would go without saying. But I guess where the law is concerned, there's nothing that goes without saying, so you have to say it. Anyway, statement of facts, the Waldman statements, and evidence relating to the Waldman statements at trial. This is just a review of what... So the issue of the appeal is a statement that Adam Waldman made for which Johnny Depp was found liable. The principle being that Adam Waldman is acting as Johnny's agent, and therefore whatever he says is basically what Johnny says. And this document is attempting to counter that argument. So, in the argument, the trial court erred in denying Mr. Depp's motion for summary judgment and evidence to strike, and talks about how these get reviewed. Now the discussion. Mr. Waldman is an independent contractor. So, what does that mean? That means that he is not an employee of Johnny Depp. He is a contractor for Johnny Depp. So, if you work for Walmart, if you're a cashier, Walmart tells you when you need to show up, what you need to do, where you need to be, and all that kind of stuff. They have the right to do all of that, and in exchange for that, you get a paycheck. And your paycheck is either based on an hourly wage or a yearly salary. In the case of something like a lawyer, Waldman runs his own company. Johnny Depp is not his only client, and therefore He is not an employee of Johnny Depp. Johnny Depp does not give him a regular paycheck every week. He gets paid for services rendered. So Johnny Depp is basically buying something from Alan Waldman, and that is his services as an attorney. So in this sense, Waldman is not an employee. He is an independent contractor. I find the language used in the law that they're quoting here really interesting too, because instead of employee, they use the word servant, and instead of employer, they use the word master, which I think gives you kind of an indication as to how long ago this statute may have been written. But regardless, or maybe they're just terms of art in law, I don't know. But I thought that was kind of interesting because nobody uses those terms anymore. Ms. Heard presented no evidence of Mr. Waldman's actual malice. This is something that I noticed as well. In order to find defamation against a public figure, you need to prove actual malice. And we've been over this a number of times, but actual malice means that you're acting either knowingly falsely or with reckless disregard for the truth. And they didn't present any evidence that Adam Waldman knew what he was saying was false or had a reasonable basis to believe it was false. By all opinions, Waldman, as far as I can tell, was saying what he actually thought. And based on the evidence at trial, it's not an unreasonable thing to think. But there was no evidence of that. So there you go. In context, the Waldman statements are not actionable. So this is another thing. An actionable statement is a statement of fact. If I say John Smith committed fraud, I am accusing John Smith of a crime. I am alleging a fact. If I know that fact is not true, or I have a reasonable basis to believe that it might not be true, then I am making that statement with actual malice. If I'm just stating an opinion, if I say, hey, it looks to me like John Smith might have done something fraudulent over here, that's not an actionable statement. I'm just saying what I think. And what I think doesn't really mean anything in terms of the law. The trial court erred in denying Mr. Depp's proposed jury instructions. So yeah, he wanted to make, Johnny's team wanted a jury instruction that would instruct them about the independent contractor thing. And that was denied. So they're saying that the judge was wrong in denying that she should have allowed that. Evidence was presented from which the jury could have found that Mr. Waldman was an independent contractor. So there was evidence presented in the trial about how Mr. Waldman does his work. And had the jury been instructed about the independent contractor thing, they could have looked at that evidence and said, yeah, he's an independent contractor. And then there is a discussion of that. And then the final item is that the unredacted articles provide the necessary context. So at trial, they were only allowed to present certain portions of the articles in which Waldman's statements were made. But there were other parts of those articles that would make it clear that what he was saying was his own opinion and that they were not allowed to present that. So I think this is extremely well constructed. They lay out, said, this is what the law requires, this is what the judge decided, and this is what actually happened, and here are the reasons why it shouldn't have happened. So, yeah, good stuff. So, let me pull out a few things that I think are just really nicely done here. Okay, so here's the bit about the independent contractor stuff, and I'm just going to read through this really quickly because it's a good example of how they're supporting this contention that he is an independent contractor. Ms. Heard presented no evidence at trial that Mr. Depp was personally involved in directing or making the Waldman statements. Instead, she chose to pursue a pure vicarious liability claim against Mr. Depp, contending that he was liable for Mr. Waldman's allegedly defamatory statements simply because Mr. Waldman was his attorney. Ms. Heard's proposed jury instruction on her counterclaim, which the trial court adopted and gave to the jury, were based solely on a vicarious liability theory that did not require a finding of any conduct by Mr. Depp in connection with the Waldman statements. That claim fails on a threshold issue, whether, as a matter of law, Mr. Depp can be held liable for the intentional tort of defamation based solely on statements made by his attorney on a pure agency theory. So, what he's saying in this paragraph is that what Amber's team said was that Waldman is Johnny's agent. Therefore, anything that Waldman says is essentially something that Johnny is saying. And what Johnny's team is saying is, no, you can't say that because Waldman is an independent contractor. He does his work his own way, and he is alone responsible for whatever he says unless he is specifically representing Johnny. In the context of vicarious liability, Virginia has long recognized the distinction between servants and independent contractors and follows the well-established rule that a principal is generally not liable for the tortious conduct of an independent contractor. So that's exactly what I just said. And there you see that servant language there, which is a little weird. Mr. Depp has not been able to identify any Virginia Supreme Court authority squarely considering the specific issues of whether an attorney retained in connection with litigation is an independent contractor and whether the principle limiting liability for conduct of an independent contractor applies in the principal agent context, specifically with respect to the attorney-client relationship. Notably, the Virginia Supreme Court has cited with apparent approval the restatements approach, which limits the liability of a principal for the actions of a non-servant agent. So what they're saying here is that the Virginia Supreme Court has not really ruled on this, but they kind of seemed to approve of an argument along the same lines in another case. But what they're saying is that this is an appropriate thing for the appeals court to decide on because the Supreme Court has not decided on it. However, although other jurisdictions are not uniform, so again, there's no overarching rule in Virginia that covers this. The majority rule, and the rule that should be adopted by the court, is that an attorney retained by a client for litigation, though undoubtedly an agent of the client in the litigation, nonetheless stands in the capacity of a non-servant agent, that is, an independent contractor, and therefore the client is generally not vicariously liable for the lawyer's misconduct, absent exceptions to the general rule that are not present here. Although the authorities are not unanimous, most other jurisdictions have considered the issue, have concluded that attorneys retained in litigation act as independent contractors, and those jurisdictions have accordingly imposed limits on clients' liabilities for tortious acts of their attorneys. And then they cite a couple of cases about that. So what they're saying there is that, okay, so there is no specific decision from the Virginia Supreme Court on this, and various jurisdictions have ruled various ways, but most jurisdictions have said that if it's a non-servant, that is, if he's an independent contractor, then the person who hired him is not liable for what he says. There are sound reasons why multiple jurisdictions have concluded that the vicarious liability should have a limited application in the context of the attorney-client relationship. Lawyers, as legal professionals, typically are not subject to their client's control with respect to the manner in which they provide their services. If clients cannot control the details of their attorney's work, it makes little sense that clients should nonetheless be held accountable for their attorney's tortious actions. Although a lawyer is subject to the client's direction with respect to the goal of the representation, It is the lawyer who has wide discretion as to the means by which those goals are achieved. In every American jurisdiction, including Virginia, a lawyer is required to exercise independent professional judgment and is subject to independent professional and ethical obligations. Further, a lawyer is prohibited from advancing frivolous arguments on behalf of a client. And a lawyer has a duty of candor to the court and is permitted to refuse to present evidence on behalf of a client that the lawyer reasonably believes to be false. A lawyer is, in sum, required to exercise professional expertise beyond that of a typical client. This is a really good point here, which is saying that the lawyer knows a lot of stuff that the client doesn't know, unless apparently the client is Darrell Brooks, who knows everything. And that the lawyer has responsibilities to people other than the client as well. The lawyer has responsibility to the bar, the ethical standards of the bar in that state. The lawyer has an ethical obligation to the court. And so the person hiring the lawyer cannot control the lawyer completely because he doesn't know enough to know how to do it. And there are other people that the lawyer answers to. So I'm gonna end it here, because I think that kind of sort of makes the point of what I'm trying to say about this document, which is that it is, it's tight. Like there's really nothing in here that you kind of look at and you go, huh? They lay out very specific reasons why the court should have done something differently, and then they argue those reasons with evidence from the law and various case law and items from what happened in the actual trial. And when I watched some of the other folks go through this, I was just kind of blown away by how tight this thing was. Like, I wish I could write something this well-reasoned. So, I think it just speaks to the skill and expertise of Johnny's team, and in particular Ben Chu. So that's good. I'm interested to see what Amber's her brief is going to look like. She has good lawyers, so I don't think it's going to be terrible, but she doesn't have much of a case, so I think it's going to be a little more scattershot in terms of how the arguments land. I think reading through her document is not going to be as much of a wow, that's a good point kind of experience as this document. I'm not saying her lawyers aren't going to make any good points. One of the things that I really like about watching Emily D. Baker's channel is that even when she hates someone, if they make a good legal point, she'll go, okay, that's fair. Like she was doing that during the Darrell Brooks trial. And Darrell Brooks is just an odious human being. And she's sitting there watching him and yelling at him and then going, it's like, oh my God, that's ridiculous, you idiot. Okay, that's fair. Oh my God, you moron. So I think Amber's brief is going to be much more of that sort of experience than this one, where you're just kind of going, yeah. I don't see a problem with this. Of course, I'm not a lawyer, so I'm sure there are ways that lawyers could pick holes in this. That's what they're trained to do. But like I said about Nate's point in writing for a general reader, for me as a general reader, this seems pretty airtight to me. But we'll see what the court thinks about it. I'm really going to be interested in reading the appeals court judgment when it comes out. Assuming that there is one. Anyway, I know this was a little longer than my usual thing. I'm glad you stuck with me if you made it this far. As always, thanks for being here. Hope you're having a great day. Talk to you soon. Graham out. Bye.